Yes, 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 yes.
No theatrics.
Huh? It is about the facts. You know, you've been told that this is a flight risk. The lady was arrested due to media pressing. That the person before you, in the other matter, is not the suspect. So this is she's facing the wrath of a public campaign. So she was never part of the people to be arrested. And she was only arrested outside my offices as we were here before you. Huh? It was around 4 something. Yeah. As we were here, the DCI was arresting her from our offices. Therefore, it's not true that that respondent is a flight risk. She had filed in the High Court an anticipatory bail application. Shadrach will get it shortly here. And when we served the DCI, because we were told to serve, and the matter is coming up on Thursday, the 24th, it jolted the state. And they came for her from her lawyer's offices. That's why she's here with you. My good friends will deal with the affidavits and the facts and the law as presented. That's all from my side.
This application is opposed. And in opposing it, we invite the court to the law, specifically Article 49(1)(h) and Article 51 of the Constitution. We are talking of personal liberty of an individual. And this being a court of law, must only read that which has been brought before it. Sorry, of the Constitution, yes, the Constitution. And I was adding that this being a court of law, is only guided by that law. You know, we are talking of a personal liberty of an individual. Which liberty is this court is being asked to curtail through the notice of motion that has been presented before you, whose sections that motion has not captured, and whose affidavit in support thereof has not been commissioned. Because I'm saying has not been commissioned because I only know that there's a commissioner for oaths when there's a stamp affixed onto a document for it to have the value of the law. But the most important of the issues that have to be looked at in grant or denial of the orders being sought are the facts as contained in the motion and the affidavit. They are seeking for 5 days, but the grounds in support of the motion do not support that. Ground number one, the weighing and sampling has already been done. So it is not right for the state or the applicant to say that they want to retain her for the exercise to start all over again, when the paperwork by them has already exhibited that the weighing has already been done. Number two, that the sweets and cookies which were realized from the premises have to be examined by way of laboratory testing. She does not work at the laboratory. They already seized. They are not with her. She will not interfere with anything, any report that may come from the laboratory. If she was to interfere, that interference has not been brought by way of the documentation that is before you, that she is going to interfere at the laboratory to otherwise twist the result or the report that will come from the laboratory, because that influence has not been exhibited here. Ground number three, that they intend to interrogate her in furtherance of other arrests. The Constitution protects her still. That she can even decide to remain mute, silent, utter no word when they are doing the investigations. In any event, there has not been attached any intended or draft charge of the eventual charging that they have to prefer against her, so that in any event we know that she is being held on account of an investigation which will culminate into a particular charge. That has not been annexed here. Equally, from the time of arrest yesterday, we believe there could have been investigations that have been carried on. Nothing could have been easier for them to even attach a copy of their investigations diary onto this application to indeed exhibit that, yes, we are not just retaining her for the sake of it, but we have undertaken steps to mitigate on the time that they have to retain her, by way of exhibiting even an investigations diary to show that that has been ongoing. There was talk of her being a flight risk. It is not anywhere in the application that she's a flight risk. And we are used to these things, just throwing words, sweet words, that she's a flight risk without attaching any evidentiary value onto the same.
I think my colleague has not read the notice of motion properly.
I'm on my feet, Your Honor. They'll have time to respond.
No, I'm misleading the court. If you look at clause 1.
I'm going to put my pen down. Run the risk of losing time.
Yes. Your Honor, so that I give the rest of my colleagues time to talk, we have, there is also an issue of suspicion that she's she might interfere with witnesses and investigations. That is just something that has been thrown to you so that you can imagine the court can also insulate that she is going to interfere with witnesses. There is no inventory that has been presented before you to show that this is what was obtained from the time of arrest. And issues of being a repeat offender, Your Honor, there is a presumption of innocence. This matter, she has not been adjudged guilty by the court, and this is now putting the cart before the horse that she's a repeat offender, when in fact there is not even a single charge before you. So, Your Honor, in a nutshell, so that I give my colleagues time to talk and submit, is that this application is hollow. It does not have any legs to stand on, and arrests, as we know them, they ought to proceed after investigations are complete. I hand over to Cliff. These have been conducted and are done. If they had the intelligence that the respondent was in commission of a crime, that intelligence ought to have been complete before rushing to arrest and then come to court to seek for time to extend investigations.
Compelling reasons. Antecedents have been handled by my colleagues. But for the prosecution to actually rely on it, they must prove that.
For the prosecution to rely on
Antecedents. They must actually prove that. And the best way to prove that is to show documentation. So they come here and give you a case number and tell you somebody was fined after plea bargaining. Do you have that on record so that they can convince you? It is not there. So that compelling reason starts dying now. They come to the next every point and they tell you they have the strength of their evidence. But they're telling you they are still investigating. So what evidence are we talking about if it's not an assumption? Yes. Should make that the accused person remains in custody. But then, in the same breath, they are telling you they are investigating this matter. So what strength of evidence are they talking about? If they have evidence, let them attach it. In the absence of that, compelling reason still keeps on falling down. They come and tell you that the respondent fled from the scene. Which scene? They must tell you the scene, place, time, and fled from who? Exactly. Who apprehended her so that she managed to escape? In the absence of that, yes. Yes, sorry, Your Honor.
Must tell you the applicant.
Yes.
Tell you which scene is
Which scene she fled from? What time?
the time.
Yes. And the person who says that this person fled from the scene must be able to tell you whether they had apprehended her or not. So they cannot come here with guesswork and start telling you so that you assume it is true. He who alleges must prove. So they are telling you they want to weigh. They want to sample. In as much as counsel has touched on it and that they have done it before. I repeat what I said yesterday. Is it necessary for her to be present to do that? If it is the law that she must be present and refuses, there must be a penal issue in case you do, just like fingerprints.
So is it the same as the lane itself?
Yes. You know, just like fingerprints. If you refuse to take, they bring you to court. Then they're telling you, in this weighing and sample, it's compulsory. From where? That avenue is open for her to pick somebody to represent her. In any case, if she says no, she does not want to appear for the sampling and the weighing, does this override Article 50, where she cannot incriminate herself, or where she chooses to keep quiet? Does it override that? Ultimately, the Constitution is supreme. So therefore, what you're being told cannot be genuine, cannot be true. And then you're being told her conduct. And counsel used the word, by that very fact, shows that she will be able to interfere with the witnesses and the investigations. And he says the word fact. You are being told of a future event. How is that a fact? That might or might not happen. In any case, Your Honor, the case of Dwight Sagarai that we gave yesterday, and if I add another case which I'll give the citation, the case of Richard David Alden versus Republic, case number 48 of 2016. Yes. Versus Republic. Case number 48, HCC 48 of 2016. Yes. Luckily, I was in both cases, so I can be able to just remember. This was just before Justice Lecit. You'll get it, yes. Justice Lecit indicates in that judgment, in that ruling, actually, it was a bail application, that you cannot come to court and tell the court that this person will abscond, will interfere, or will do anything without laying that material before the court. It is not right for the prosecution to come to court and say that a person will abscond, will interfere with investigations without placing material before the court to show that it has actually happened or attempts have been made to do so. In the affidavit, they have not said she's going to abscond without putting material before the court. It has happened directly or indirectly. Because that way the court is left to assume, and the sky is the limit when assumptions come about. And Your Honor, this is why we have this fundamental right, so that you can safeguard such stories or such excesses from the state, because they will say anything. It's in their DNA. So such that, Your Honor, when they come and make such sweeping statements without giving you any other material to support, do those conditions then, let me put it in a different way. In the absence of the compelling reasons, then what happens? Then this right becomes absolute. In the absence of those conditions, it becomes absolute. So how does the court address this then? Your Honor, you give terms and conditions that can be fulfilled by the respondent. They must be reasonable. So that the person can report if the court wants him to report to the investigating officer or to the court itself. Deposit travel documents and anything else the court finds reasonable to do so to secure in the case of Dwight Sagarai, the court indicated that will interfere. All the court needs to do is to put safeguards to ensure that this person does not communicate or interfere with those with the Criminal Procedure Code. They also needed to show the court one thing, that so far this is what we have done since we arrested. So far, have they shown you anything, Your Honor? This lady has just been sitting in their presence and they did not even give her tea. So I'm not saying that they are bad people, they are my good friends, but then they can't just take and keep her there until they want another 5 days and they have nothing else they're going to do about it. So, Your Honor, time. Yes. You are being told that due to time factor, confirmatory laboratory tests have not yet been done, hence no report yet. That is number 8 of the paragraph, the supporting affidavit. It's the same question, Your Honor. I'd expect that maybe you would even ask yourself, what do they want her to do about confirming the laboratory tests? What do they want her to do with the cookies? Then they tell you it needs expertise. They use such strong words, expertise and high skills, which she does not possess. Or if they're saying she does, they're not saying which ones. And one last thing is paragraph 7. They say that the investigating officer is planning to make more arrests on the suspect's accomplices. They do not expect her to go and arrest with them. They are not saying which suspects. She has no arresting power. But because they are looking for people out there who have no names, they are asking you, please put her in custody. How fair can that be? Personal liberty is really, really something that you can say sacred. And that is why, Your Honor, so that I do not even recite those articles of the Constitution. I'll just quote my favorite one, Article 19. These rights belong to an individual and not the state. This is the favorite child of the court today. The favorite child of the court. Anybody else is secondary. And that is why the court must protect the suspect, the respondent, or an accused person. And not the state. To you, she has no other protection. From my partner.
Yes, Your Honor. Thank you, Your Honor.